Can an advocate hold your critical case documents hostage? The Supreme Court of India has answered this case decisively in the landmark case of R.D. Saxena vs. Balram Prasad. The Supreme Court has delivered a judgment that has become a cornerstone of professional ethics for lawyers in India. The court held that an advocate has no right of lien on a client's case files. The advocate's duty to the client and the justice system is higher than their own personal financial interests. The Supreme Court stated that files should be returned to the client. Let's talk about a situation that many clients fear. You have a dispute with your lawyer, perhaps over fees, and you decide to change counsel. But when you ask for your case files back, documents that are crucial for your new lawyer, your old lawyer refuses. They say, "Pay me first, then you can have your files." Is this legal? Can an advocate hold your critical case documents hostage? The Supreme Court of India has answered this case decisively in the landmark case of R.D. Saxena vs. Balram Prasad. Let's break it down. The case was simple. Mr. Balram Prasad Sharma was a client, and Mr. R.D. Saxena was his advocate. A dispute arose over the advocate's fee. As a result, Mr. Saxena refused to return the case papers to his client. Mr. Sharma filed a complaint with the State Bar Council, which found Mr. Saxena guilty of professional misconduct. The case eventually travelled all the way up to the Supreme Court of India. The central question was this: does an advocate have a lien over the client's files for the unpaid fee? Mr. Saxena's main defense was based on Section 171 of the Contract Act. This section grants a general lien to certain professionals, like bankers, factors, and attorneys. A lien is a right to keep possession of property belonging to another person until a debt owed by that person is discharged. So Mr. Saxena argued that as an attorney, he has a right to retain his client's property, in this case, the files, until the fee was paid. This brought Supreme Court to the most important question: are a client's case files considered goods or property over which a lawyer can exercise lien? The Supreme Court has delivered a judgment that has become a cornerstone of professional ethics for lawyers in India. The court held that an advocate has no right of lien on a client's case files. Here is the reasoning. The court clarified that the word goods in Section 171 of the Contract Act applies to movable property. Case files, however, are not goods. They contain sensitive information and are the client's personal documents. They are not a commodity that can be held as security. The court emphasized that the relation between a lawyer and client is that of a fiduciary one. This means that it is based on trust and confidence. The lawyer holds the client's documents in a position of trust. Using those very documents as leverage against the client is a breach of that trust. The court concluded that retaining a client's file for non-payment of fees is an act of professional misconduct. It obstructs the course of justice, as the client cannot effectively continue the case with a new lawyer without those papers. The advocate's duty to the client and the justice system is higher than their own personal financial interests. The Supreme Court stated that files should be returned to the client, and the advocate's remedy for recovering unpaid fee is to file a proper legal suit for recovery and not to hold the client's case as hostage. So the law is crystal clear. An advocate cannot refuse to return your case files over a fee dispute. The R.D. Saxena judgment protects the client's interests and upholds the integrity of the legal profession. It ensures that the process of justice is not held to ransom. Your files belong to you and you have the right to access them at all times. I hope this clarifies your rights as a client. Thank you for watching. If you like the video, please subscribe to this channel.